Kindly have a look to 13th of September 23 order. First day, nobody appeared. On the second day, Mr. Sonjit Kumar Ghosh appeared for the respondents, and there was the direction to file affidavit in opposition. By 6th of October 2023, reply 19th October, affidavit was not filed. Then the next order that was passed on, 13th of September 23 order. I don't know.
দেখুন তো someone is whether someone is appearing through online or not.
Now on 22nd of November, 2023, the Justice Mantha, coordinate bench was pleased to extend the time to file affidavit in opposition, but upon payment of rupees, cost awarded at rupees 8,500, 22nd of November 2023. Even then, the affidavit in opposition has not come as yet. Then Lordship kindly sees on 29th of February 2024, despite second extension of Justice Mantha's order, kindly have a look. Despite second extension of time to file affidavit in opposition with against costs, the respondents have not filed an affidavit till date. Having heard Mr. Dotto, line advocate the petitioner, let this matter stand adjourned, be listed on 5th of March 2024, marked as part heard. It was extensively heard by Malala, but
okay, I am fixing one date. You give a notice if they come.
Kindly fix the date.
They would be heard. Otherwise,
kindly Malala indicate that in default of their appearance, the matter will be. Otherwise, Malala, they won't appear.
Yeah.
Kindly fix the date.
Despite service, the respondents is unrepresented. Stop. The supplementary affidavit as filed on behalf of the petitioner is taken on record. Stop. To afford another opportunity to the respondent to appear in this matter, the matter stand adjourned. And yeah, কবে আসতে দেওয়া যায় একটা ডেট দেখুন এপ্রিলের কাছে পিঠে আছে কিছু হ্যাঁ 1 তারিখ কোনো ফিক্স নেই হ্যাঁ না দুটোর সময় হ্যাঁ আচ্ছা let this matter appear on 2nd April 2025 at 2 p.m. At 2 p.m. Stop. Achha, Mr. Petitioner is directed to communicate this order to the learned advocate who entered appearance on behalf of the respondents previously when the matter was taken up for hearing. Okay? Achha, it is clarified that if now a respondent remain unrepresented on that date, the matter shall be taken up for hearing even in their absence.
Yes.
Okay.
2nd April at 2 o'clock. Great.
My Lordship, I appear for the petitioner. To this writ petition, we have challenged the compulsory retirement that has been imposed upon me. And on the last date of hearing, my Lordship, and direction was given upon the respondent to file the affidavit in opposition. However, till date, they have not served a copy upon us. The matter was lastly taken as the year of 2024. To be more specific, my Lordship, 19th April 2024.
Ranjan Kumar Sinha, সৌনক ঘোষ, অঞ্জন কুমার সিনহা, none appears on behalf of the respondent though. What's your name?
Mona Mukherjee.
Huh?
Mona Mukherjee.
Though Miss Mukherjee, learned advocate, appearing for the petitioner is present. Stop. However, to afford another opportunity to the respondent to appear in this matter, the matter stand adjourned. ঠিক আছে? Stop. Release the matter. আচ্ছা, এটা বলি, আচ্ছা, petitioner is directed to serve a notice upon the learned advocate on record of the respondent, intimating that the matter shall be taken up for hearing on 3rd April 2025. Yes.
This is an applications for revisional applications. Here is the impugned order was passed by the special court, whereas the petitioner's was in petition number 2 was in the custody sitting after arrest, and he was released on bail by direction of this honorable court to deposit the bond, my lord, and also surety. Accordingly, the petitioner shall be released on bail upon furnishing bond of ₹10,000 with 2 sureties of like amount, one of whom shall be local to the satisfaction of the learned Chief Judicial Magistrate, Howrah. Now, I have already deposited the fixed deposit 1,50,000 and also my lord 10,000. Now, this 1,50,000 my lord has been my lord seized by the learned Chief Judicial Magistrate at Khatra, that is page 14. Page 14. It has been addressed to the manager of the concerned bank. The undersigned request him not to transfer for in case without the court's order the community trans deposit in respect of account number such and such in favor of Miss Urmila De. That is the petition number 1 of 46 Tripura Rai of that address of rupees 1,50,000. That was seized, my lord, because thereafter, my lord, I made an application only on the ground that I was need to operate the knee, the 2 knees before the hospital. Now the want of money, my lord, that amount has to be, my lord, some amount to be released. That's why this application was filed, which was, my lord, applications was being number, my lord, SPL year number, that is page 15, 170 of 2018. Now this application was heard by the learned special court, whereas the entire file and records are lying with this special court. Now, you'll also kindly see 20th July 2018 that under CRM number 5031 of 2018, an amount of 1,50,000, that is the fixed deposit, and also, my lord, page 21, 10,000.
Who is for the state?
Well, statement, this is a revisional applications until or unless notice is not served, then state, my lord, I cannot serve. Because it is urgency on the, my lord, basis of the operation. Now, entire amount, my lord, 1,50,000 plus 10,000 has been deposited to the, my lord, bank, and it was seized, my lord, by the Chief Judicial Magistrate, but the landed court below on 16 January 2025.
Okay, you serve.
My lord, my lord, your losses kind, my lord, as soon as possible, my lord.
Okay. Your money is required.
Yes,
You will. The instant revisional application has been filed, challenging the justifiability of the order dated 16th January 2024, passed by the learned Judge Special Court, SC/ST Act, Howrah. ঠিক আছে? having heard the learned advocate repenting the petitioner, I am of the view that here presence of the representative of the state is crucial for effective adjudication of this here, and accordingly, the petitioner is directed to serve a copy of the application along with all annexure thereto upon the in the office of the learned public prosecutor next to
Only state is obvious.
in the office of the learned public prosecutor and file a affidavit of service on the returnable date. This is the matter for further consideration on 4th April. 4th April. Yes, next. The cow has been given in Jimma petition number 2 Jalauddin Mondal. Who are you?
My lord, I am the petitioner who is running a animal welfare organization,
Dhyan
Foundation.
Gosala.
Dhyan Foundation.
Okay.
My lord, the case is, my lord, that this is a matter under the Prevention of Animal Cruelty Act, read with the relevant rules. My lord, as per the Prevention of Cruelty Act and the rules, my lord, if any cruelty is inflicted upon an animal while in the transportation or in the care and custody, then when the law says that while the investigation is going on and the matter is pending, the custody cannot be given to the owner or the accused. The custody has to go to the animal welfare organization. And my lord, there is a judgment of this Honorable High Court Justice Subhra Ghosh interim order is there. There is a judgment of the Honorable Division Bench also, my lord, Honorable Chief Justice. And there are Supreme Court judgments also. I will refer to that later on, my lord. So the law very clearly says that the custody cannot be given to the accused under any circumstance. My lord, the learned Chief Judicial Magistrate granted the custody in favor of the petitioner, who is running more than 40 animal shelters across the country. Even in West Bengal, there are shelters and the place to take care of the animals. And the petitioner has been recognized by the Animal Welfare Board of India, which is the highest authority of the government of India, and also the Border Security Force for their services rendered for the welfare of the animals. Now the Honorable Session Judge, the Honorable Chief Judicial Magistrate, considering the judgment of the Honorable Supreme Court, rules, regulation and the act in this regard, granted the custody to the petitioner as the petitioner, the estate expressed inability to take care of the animals. Now, my lord, the Honorable Session Judge has granted custody to the accused, and if your lordship sees the accused says that I am so and so, but I am also known as so and so.
Okay, give notice to other side and come.
Yes.
This would be okay. Achha, this present application, this application has been presented to challenge the propriety of the order dated 11th February 2025 passed by the learned Additional Session Judge Second Court Howrah in a criminal division by number 03 of 2025. Stop. The petitioner being the Dhyan Foundation Gausala submits that as per the settled principle of law, after the settled proposition of the law set forth in series of judgment by the Honorable Supreme Court as well as by this Honorable Court, the learned trial court cannot hand over the custody of the animals in favor of the petitioner during pendency of the criminal
Not in
trial.
favor of the in favor of the accused.
In favor of the accused person, during pendency of this criminal trial. But the learned court below has glossed over and stopped. This issue was raised, but this issue was overlooked and or ignored by the learned court below, and the learned court below has handed over the custody of the animals recovered during course of investigation to the accused person. However, very good. Record speaks that the 30 numbers of cows which were seized by the IO concern.
It is 59, my lord.
Page 48, 39.
They have returned it. The order for return is 39, but originally 59 was seized. That is what.
39 of the year. Return to the to the opposite party number 2 herein upon execution of a Jimmanama bond. So it appears that the opposite party number 1 is holding the custody of those cows as custodial legis.
No, the custody is with us, not with the opposite party number 1. The custody is with us. All the cattle are in our.
But order speaks that let the seized 39 numbers of cows be returned to the petitioner on execution of Jimmanama bond.
So the petitioner at that time was opposite party number 2.
Yes.
So they directed it to be returned to the opposite party number 2, my lord, the court below. But the Chief Judicial Magistrate granted custody to us, the petitioner.
Oh.
But kindly refer to the order dated 6/12/2024 of the Honorable Chief Judicial Magistrate.
6/12.
6/12, my lord. But that 6/12 order already is on page 31.
Initially, the Chief Judicial Magistrate directed the IO to hand over all the seized animal to your custody.
Yes, my lord.
That order was challenged by the
Accused.
accused, and their challenge was accepted. Now 39 has been returned to the.
Yes, my lord. Yes.
You are agreed by that order.
Yes, my lord.
Are you getting it? So the petitioner, this revisional application has been prepared to challenge the propriety of the order dated 11th February 2024, passed by the Additional Session Judge Second Court, Aura, in Criminal Revision number 03 of 2025, directing the petitioner hearing to hand over or directing, giving custody, return করে দিয়েছে। আচ্ছা, directing that the 30 numbers of cows be returned to the OP number 1 on executing a Jimmanama bond. Stopped. Acha. The petitioner submits that as per the proposition of law set forth in catena of judgment, pronounced by the Honorable Apex Court of the country as well as this Honorable Court also. During pendency of the trial, the seized animal are required to be handed over to the petitioner. Stop. And initially, the learned CGM Howrah handed over 59 numbers of cows to the petitioner. But subsequently, in a division, the learned Additional Session Judge Second Court, Howrah, ignoring the settled principle of law, has directed that 39 numbers of cows be returned to the opposite party number 1, opposite party number 2 hearing. He submits that this order was passed in contravention of the settled principle of law, and hence the same cannot stand. Stop. However, having heard the learned advocate and upon perusal of the materials on record, I am of the view that for effective adjudication of this instant revision, presence of the representative of the OP number 2 as well as the OP number 1 are crucial. Stopped in view thereof, the petitioner is directed to serve a copy of this application along with all annexures thereto upon the opposite parties hearing and file affidavit service on the returnable date. Release the matter for further consideration on 7th April. 7th April. Oh, 7th April monthly list to come on 9th.
My lord, in the meanwhile, my lord, kindly stay the the order, my lord. They are my lord, pursuing.
Whether you are in custody or they have.
No, we have the custody. So, my lord, they are seeking the return. My lord, if the ultimately it is returned, then my lord, my petition.
Oh, so
My lord,
the
there is an order of Honorable Justice Subra Ghosh also, my lord, in a similar matter.
Hello, আমি তো করে দেবো। আচ্ছা, stop. Please show me the judgment of the Supreme Court and what?
My lord, the honorable division bench judgment, I'm showing the Supreme Court document. Kindly have a look at the division bench judgment. Supreme Court. यही division bench.
How many judgments?
My lord, the Supreme Court judgment, my lord, kindly refer to
Okay.
page
Page
60 onwards. Page 60. 60.
আচ্ছা তাহলে ওইখানে যেখানে বললাম না পিটিশনার সাবমিটস আপনি লিখবেন আচ্ছা citing a decision reported
But this is not a reported judgment.
reported at 2024 volume 7 SCC page 547 bracketed Animal Welfare Board of India versus A.
The next is also similar matter, man.
Similar matter.
Yes, man.
How many numbers of you?
My lord, I have just.
Howrah, same.
73 cattle, man.
73 cattle. Revision.
Yes, my lord. The 21st
Oh, here pair of the accused person by the CGM was refused.
CGM in that also by order dated 26/12/2024 granted custody to the petitioner.
CGM?
CGM,
CGM refused.
no, my lord, CGM kindly refer to order dated 26/12. CGM granted custody to the petitioner hearing. The investigating officer is directed to hand over the said 73 members seized cows to NGO, namely Dhyan Foundation, Chakulia District, Singhbhum, Jharkhand for necessary care and shelter, and shall submit a compliance report.
This revisional application has been. So you have challenged here the order passed by the learned additional session judge in
Yes,
criminal division, whereby direction has been given to her.
Yes,
Eh?
my lord. That the return of 73 cattle in favor of the accused.
Achha, this revisional application has been prepared, challenging the Seven, 6 and 7. Yes.
Lord, I appear for the applicant petition. My Lord, I have challenged in this revisional application, my Lord, 3 orders, my Lord. First order, my Lord, on the basis of a petition filed by the prosecution lawyer, my Lord, 18 witnesses were prayed for recall. And my Lord, subsequently, the trial proceeds. It was allowed, and my Lord, in spite of Honorable Court's direction, the trial delayed. Thereafter, my Lord, on my Lord, the first order copy, if your Lordship kindly see, and that is the order for allowing recalling. How in a casual manner, without filing the, my Lord, the questioning which was left out to be asked to the, my Lord, the witnesses. Nothing was submitted, but it was allowed in a casual manner. And my Lord, learned public prosecutor in his own style, my Lord, examined those witnesses as a fresh witness. And then, my Lord, what happened on 5th February 2025, my Lord, the witness was asked the same questions which was asked previously. It was objected repeatedly. He asked. He then goes to the dock, and my Lord tried to, my Lord, pressurize him to say the same thing which he wanted. And my Lord, that is the reason for which the learned defense lawyer objected to his, my Lord, the conduct of the learned public prosecutor. And my Lord, when the court didn't take any step, rather allowed the public prosecutor to proceed in that fashion, my Lord, the learned lawyer filing an application of objection, my Lord, left the courtroom. And my Lord, the learned judge, my Lord, passed an order that since no one is there, it is deemed that the cross-examination is over. On the next day also, the same thing happened, my Lord. And my Lord, if your Lordship kindly see the order by which the recalling application was allowed to, my Lord, the prosecutor to do that, that becomes misinterpreted by the learned public prosecutor as well as allowed by the learned judge in spite of objection. If your Lordship kindly turn to the page 24 for a moment, the order of the Honorable Division Bench.
What wrong he has done?
My Lord, wrong has done, my Lord, that the learned judge didn't, my Lord, rather stop the, my Lord, the way of, my Lord, examining the witness, my Lord, the way the learned public prosecutor has done, that was objected, but that was not, no credence was given to that.
Why it has been written that all objection of the accused person?
No, my
is
Lord,
to
that
be-
is not because the fair trial is the essence, my Lord, because the learned judge is the
You
umpire.
have made some wild allegation against the PP as well as the court.
My Lord, not against the court. If your Lordship kindly see, I
So
will,
you show
I will
why?
show you. I
Your
will,
conduct which has been it
I
is-
will
it is-
show
it
your
is
Lordship.
personal observation of the court concern,
My Lord, if that be
which
so,
cannot be made subject matter
My
of
lord,
the challenge.
my lord, that is not the challenge, but that should be
At the time of appearance in the court, everyone
that
should,
is
should
that
be
is
cautioned
that is
that the personal observation of the judge
that was not
cannot
done.
be the subject matter of
That
the
was not done. It was recorded, but that was
You
not done
show the application.
because the objection of the learned PP should disclose that, my lord, whatever the learned judge recorded, that should be reflected in the objection filed by the defense, my lord. That should be seen.
Okay, you serve, let your other side come. You serve upon the de facto complaint also.
My lord,
Have you made DA? There is no use of keeping this pay or pending.
my lord, kindly see for a moment how it has been proceeded. Kindly first
No,
of all,
no, here it is appearing that you yourself most probably sensing something,
my lord,
some maybe
no, my lord, the
adverse
learned judge is saying I will convict him in the unusual manner. That is the thing, and in one matter, the Honorable Justice Supra Ghosh has taken cognizance to that, and my lord, state the
You
procedure
show
of
this application. Where have you annexed?
My lord, kindly come to, my lord, I am showing one by one, my lord. If your lordship kindly turn to page 24, my lord, for a moment, the division bench order, how it has been, my lord, misinterpreted, how it has been, my lord, taken, my lord, for the purpose of, my lord, recalling the witnesses in the name of, my lord, in the garb of press examination of the witness. My lord, learned judge says in the last paragraph that public prosecutor, it shall be open to the special public prosecutor to recall prosecution witness, if any, for a just decision of the case. My lord, if any, not 18 witnesses. If your lordship kindly turn to next page. Next
So-
page, kindly
So
see.
this court granted power and liberty to the
If any,
public
if
prosecutor
any,
to recall.
if any, not,
Whether court has used, if any, this power is always available.
no, my
with
lord,
the-
that is not, if had it been done for to unearth the truth, my lord, by the learned court, I don't have any objection. But it was done by the learned prosecutor. The next page, kindly see. So 25. Is this the way to recall the witnesses? Kindly see the application.
To recall any witnesses and petition under 311 was filed.
My
You got the chance to oppose.
lord, I oppose.
eh?
I oppose.
That application was decided and by passing an order.
My lord, kindly see how it has gone. My lord,
Have you challenged that order?
my lord, that order, my lord,
So you have allowed the said order to attain its finality.
my lord.
Now you cannot agitate the point that,
My lord,
that the witness was erroneously.
my lord, under 401, 482.
So you forget.
My lord,
Stop from raising this point.
my lord, since it has
That
been,
any witness was illegally recalled.
my lord,
The
kindly see the
power-
process. How, my lord, I have not,
Power is you will not be able to agitate,
my
re-agitate this.
my lord,
Power is available in the Code of Criminal Procedure under Section 311, old criminal procedure, because it is going
my
under
lord, that has been
old Act.
changed.
It is old Act.
My lord.
So 311 is there. The 311 has given
It
power,
can be exercised by the learned
power
court,
of the
learned
court
court.
just for just decision of a
But
case.
not at the whims of the public prosecutor. That should be scrutinized. And my lord,
That order is not under challenge in this revision.
my lord, in this petition, in this revision
No, why?
application, we
You
have
have
challenged.
challenged what you have challenged.
My lord, we have
What you
challenged.
have challenged.
Kindly see, my lord.
Papa, you have challenged 3 orders at one.
My lord, on the my lord, cost title, if your lordship kindly come to. Just on the first page, my lord. In a recent judgment, my lord, your lordship found that if the trial judge, my lord, commits any wrong, then there was an order of retrial even after, my lord, conclusion of trial. Here, my lord, I would show your lordship how the learned judge, my lord, proceeded in this matter, my lord, in an unusual manner. My lord, kindly see that application. Kindly see for a moment. My lord, we have practiced in the lower court. We know that if we pay for recalling a witness, my lord, the questions to be put in to be submitted before the court and with a copy to the other side beforehand, and not in a manner. My lord, what they have done, page
Okay,
25,
sir.
page 25, my lord, kindly see.
Acha.
A police officer is appearing virtually, my lord, it is the duty of the learned judge to ask the my lord accused whether he himself wants to cross-examine or not. That has not been done.
Okay, come.
My lord,
Hmm.
deeply obliged, my lord, deeply obliged.
On that date. Yes, next.
So this matter was heard by your lordship. This matter was heard by your lordship on the last occasion. This is in respect of that particular gratuity, quantum of gratuity. Now, my lord, I have shown before your lordship the government of India circular page 39 and the act. Can you see the act? Payment of gratuity act.
For that matter, gratuity. So your claim is that you will get gratuity
No, my lord.
amounting to 20 lakh. So you show how you will be.
My lord, on the basis of the notification, he is claiming.
My lord,
Also,
I am
the
showing.
notification
Please,
is that-
my lord, this is very bad
On
thing.
the
my
last
lord.
occasion, he has
I will make my submission, then you sit down, then make your submission.
Oh,
that is
He is from
you will
the
get the
lower court.
opportunity.
This
Why?
is difficult.
You will get
Dispute
it.
case.
Yes.
His dispute case
So
lawyer.
there is a notification
I
that,
am showing. I am showing.
that the amount of gratuity
Now, my lord, can you
shall
see?
not exist 20 lakhs. Yes,
lord,
same
can-
thing.
my lord, one thing, only.
My lord, this is
My lord,
difficult.
one thing. The senior counsel, what is he is addressing? The last occasion, he has that he is not fit for High Court. Now he is saying for dispute case for it.
It is difficult. Difficult.
The senior counsel.
He does not know how to address.
My lord, he is having last occasion.
He does
He
not
has
know.
studying me that I am not competent for High Court. I am competent for it.
Forget about
It's a senior counsel. At least
He does not.
you.
Does not know the. Does not know.
Don't
the
submit
decorum.
during his argument.
Let me complete my submission.
Okay. You will get your
Now,
chance.
now, my lord, your lordship can see the order I have shown before the lordship last occasion. Your lordship has got the order. Yes, kindly are giving. I am giving another order. Your lordship can see the order was passed by the general manager on 16/5/2022. I retired on 21st of April 2021. This order I have produced before lordship on the last occasion. I retired on 21st of April 2021. Now, an order was passed by this Honorable High Court when I moved in the writ petition to pay the admitted amounts expeditiously as possible. In the meantime, respondent bank shall disburse the admitted retirement benefits to the petitioner in favor of the petitioner expeditiously, possibly within a week. My lord, got the order of Justice Sabosati Bhattacharya? First order.
Page.
That is the order passed by the Honorable Justice Sabosati Bhattacharya on 4th May 2022. Kindly see the order of this Honorable Court. My lord, got it.
Page.
Order in the file. Order in the file. Order in the record before your lordship. First order in the. Kindly see.
This was the admitted amount. Yes.
4th May 2022.
Yes.
May I read the order?
No. In the meantime, respondent bank shall disburse the
In
admitted
the
return.
meantime, the respondent bank shall disburse the admitted retirement benefits to the petitioner in favor of the petitioner expeditiously, positively within a week from the date, without prejudice to rights and contention of the parties to the writ petition. On that basis, this order was passed on 6th May 2022. 6th May 2022 speak about final gratuity of rupees 10 lakhs, leave encashment, such as medical allowance, I am not disputing. And further said, it is to be noted that a sum of rupees 3,163 only is receivable from you. the said amount will be deducted from a retirement benefits. They will deduct itself. All the retirement benefits will disburse to SB account such and such. That was paid to me. That was paid to me. Now the point came up in a read petition that I am entitled to 20 lakhs in view of law. Kindly see page 39 of my read petition. 39 of my read petition. This is the government of India because this circular emanates from the power given by the Act itself, Section 4, subsection 3. My lord, kindly see Section 4, subsection 3. Section 4, subsection 3, my lord, kindly consider the amount of the payment of
Any
gratuity.
disciplinary proceedings was initiated against you?
We completed.
Huh?
Completed. I was punished
Punished removal?
by payment of 3 lakhs.
No.
And thereafter, they say all has been cleared.
Thereafter you joined?
Yes, he was.
You
He was
rejoined?
not suspended.
Oh, okay.
He was continuing in the job. He
So
retired.
disciplinary-
Kindly see the release order. Kindly see the release order.
Oh,
Kindly see release.
page.
Yes, that is my lord page. Page 50. Page 50. Kindly see page 50. Whereas Sri Tarabodha Barik, branch manager, CK Branch Road, will retire from service of the bank on 30th of April 2021. Whereas it is necessary to take over charge of branch manager,
It is,
then my lord, I handed over the charge, page
on attaining the
50.
age of superannuation. But-
I attained the age of superannuation on 30th of April 2021. And I was released on 30th of April. I handed over the charge on 30th of April. Kindly see.
No, so-called notice was given thereafter. A charge sheet was issued and he replied to that charge sheet. Thereafter, what was the fate of that?
Yes, then the
On receiving of his
the
application for apology in his meeting,
punishment said, my lord, paragraph
instead
48.
of dismissal of
Paragraph 48. This is not the issue here.
Oh,
Issue is with regard to
regard to payment of
payment. Kindly
gratuity.
see section 4. Section 4, subsection 3. Issue is section 4, subsection 3. The amount of gratuity payable to an employee shall not exceed. My lord, put a question on me on the last occasion. Shall not exceed such amount as may be notified by the central government from time to time.
Hmm.
My lord, kindly see the last note. Central government issued a notification on 29/3/2018, clause 5. No, nota bene, 5. Amount of gratuity payable to an employee shall not exceed 20 lakh rupees. Then the notification, your lordship can see, I have given the notification, page 39.
Page
39. Notification of Government of India, Labor and Employment departed. Page 35, that is 29th March 2018. My lord got it. 29th March 2018. 39. Kindly see second paragraph. 20 notification 29th March 29th March 2018. In exercise of powers conferred by subsection 3 of section 4 of the Payment of Gratuity Act 1972, the central government hereby specifies the amount of gratuity payable to an employee under the said act shall not exceed 20 lakh rupees. Shall not exceed. Your lordship put me a question which shall not exceed. Now that question has been settled by them. They say it will be 20 lakhs. Kindly see their own present circular. Kindly see the present circular. 21st of January 2025. It is hereby informed to all concerned that in terms of decision taken by the special officer of the bank in its meeting dated 17 January 2025, in conformity with the, my lord, kindly I am giving emphasis, in conformity with the Payment of Gratuity Act, the upper ceiling of the final gratuity has been enhanced from 15,000 15 lakhs, 15 lakhs. I was given only 10 lakhs. Kindly consider 15 lakhs to 20 lakhs with effect from 1/4/2025. My submission before
Yes,
your lordship, whether the date of effect can be curtailed by a particular officer or a particular employee of a particular cooperative bank. Government of
Yes,
India,
yes.
Government of
Voice
India,
for the cooperative bank. Yes.
Government of India.
Okay, what is your expression? Why have you not given?
My lord, yes. Although I have got this copy from my learned friends, but fact remains this decision has been taken in the 2025. Now he has resigned.
Well, my first,
he has come
my
2021, when the rate of 20 lakhs was prevailing.
at that point of time, 18.
Of the board and the decision of the agreement between the union and the bank, and all on the basis of that. Not since the 25 and get returned in 2021.
Fact finding dispute hole is
It-
continue authentic.
And question is this, my lord?
Have you got this book?
Yes, my lord.
This notification is of 2018.
18.
Yes, 2018. But question is this, my lord. There was an agreement. I will show before the very beginning opposition. Opposition to file. Anyway, I am filing it. There was an agreement in between the cooperative bank and the union of the employees union, and on the basis of, and they have, I will show the prayer of the repetition. They have also never paid for that, and we have paid only for the retirement benefit according to terms and conditions and the as given in the agreement. On the basis of the agreement, I will show the prayer of the repetition. Question is this, my lord, that 20 lakhs is subject to notification. Now I am seeing correctly that 15 lakhs to 20 lakhs, although it is instruction is required. But fact is this, my lord, that he has returned in 2021. How is entitled to 2025 for that decision? That is the basis of his claim.
Court asked your question, the notification of 2018.
18, yes, my lord.
Second question would be that a agreement entered into by you and union
Yes.
can be against the provision of a law.
No, my lord.
And if it is found, then that part would be treated as a void.
Yes, my lord. My lord, I have.
এটা ফাইল করে দেবো
My lord, kindly let me give you the reply. Kindly, I am.
এটা fact finding
Yes.
My lord, I have already taken in the preliminary objection against the repetition, maintainability of the repetition. There are so many.
Forget about the maintainability.
Because
Yes.
it is single bench. My lord,
The court by passing an interim order, the problem is that you should calm reading everything. The court, by passing an interim order, has effectively overruled your objection.
No, my lord, point of maintainability, my lord,
Okay.
has not been decided.
Okay, point of maintainability, you are saying that without exhausting the alternative remedy available to the petitioner, he has come. How many judgments you will take?
Now, I will show
Okay,
before lordship for
there is no complete ban on the court. There is no rule. There is no act. There is no provision in the constitution. If court found willful judgment that there is a violation of the fundamental right, withholding a retirement benefit of a particular employee who has you have exploited his service for the entire life is not a violation of fundamental right.
Yes, ma'am.
So,
Of course.
if court
Tax
finds that there is a violation of fundamental right, all the will get removed.
But tax
Okay, you show us the specific
my
portion,
lord, I am,
specific portion
lord, I am-
regarding payment of gratuity.
yes, my lord, I am coming. Because the writ petitioner claimed equal lawsuit. First of all, you have to see, my lord, whether there is a prayer or not in the writ petition. First,
Retirement benefit
But
include payments of gratuity. I have seen retirement benefit. Don't say whether any payer or not.
yes.
You are before a constitutional court which has a power to mold the relief. You
Second, my lord,
you draw my
am-
attention only to the specific portion regarding the gratuity, payment of gratuity, not more than that. Where page
agreement can't.
gratuity, payment of gratuity, page 20, internal page 20.
No, section 7.4.
Oh,
7.4 AB.
oh.
My lord, না না ওগুলো মেন্টিবিলিটি পয়েন্ট আছে হ্যাঁ জজ সাহেব যদি জিজ্ঞাসা করছে একটা ফার্স্ট হচ্ছে যে ওই জিনিসটা এ করেছে যে
Come to page 51 of your affidavit in opposition.
Yes.
Come to page 51.
হুম,
It cannot be.
yes
51,
Yes.
got?
Yes.
Now come to every employee shall be eligible for gratuity as
Yes.
per Payment of Gratuity Act.
yes
That means the no provision in the agreement, no terms and condition in the agreement which can go against the Payment of Gratuity Act.
Yes.
So your authority is duty bound to obey the provision of Payment of Gratuity Act. That agreement will be invalid if it is made against the Payment of Gratuity Act. Now you come in 2018, the central government issued a notification. Maybe he retired in 2021. That notification is binding upon you. So pay the amount.
my lord first
Pay the amount, don't.
no my lord let me submit I have something
Yes, go on, sir.
I see section 7.4 A and B that if
Huh?
any dispute arises section 4 payment of gratuity act section 7.4 AB
Huh?
because he was habituated for once he has been punished by way of payment of thereafter again he done the so-called notice was issued during his period of service and my lord at the same time he was transferred. But what fact is this, my lord, he is not a fair way. That's why, my lord, I am
And hence you have withheld the gratuity amount.
I'm not
Withholding of the gratuity amount is an offense.
gratuity according to eligibility of the
Yes.
claim has been given.
Show us that provision.
দিতে দেখা without payment. Part payment done.
Section 9.
ওটা নেই তো Section 9 ওইটা না দশে বলছে সেকশন 9 তো
Yes, Mr. Roy, you are appearing for?
I am appearing for state.
State. You along with Mr. So you? Respondent number 6.
মানে apart honor before section 9 section 7.4 A and B there.
Forget about
my lord
My lord,
Oh,
section
you
7
forget about your again section. It is Constitution 226. Court has found the prima facie found there is violation of principle of national justice. Forget about all statute.
But section 7(4) says if any dispute
Oh.
is there, if any dispute is there,
Huh?
interest, including interest on penalty.
option is there, section 7(4).
Section 4A and B. Kindly see my
Section 7, subsection 4.
subsection 4A and B.
Part payment করছে।
No, part payment, my lord, part payment already paid. Part payment admissible benefit has been returned, gratuity has been given. But rest of the portion, my lord, kindly.
Mr. Bhattacharya, they
They
are referring section 7(4) and
A and B.
A and B.
Yes.
If there is any dispute as to the amount of gratuity payable, acha. Who is the controlling authority?
My lord, labor tribunal. My lord, the honorable of this honorable High Court, my lord, coordinate bench and the honorable division bench already affirmed in this regard regarding the cooperative bank. And Judge Dipankar Datta, honorable division bench passed this order regarding, yes, my lord,
So.
that order. No, my lord, order. Or order টা চাইছেন স্যার?
Justice Dipankar Datta.
Yes. এই order টা না এটা Dipankar Datta না, আমি just আরেকটা আছে। হ্যাঁ, yes, my lord. Apart from that, there are so many serious Supreme Court judgments in this regard regarding. Judgment clause, huh? আমার লিস্ট অফ জাস্ট
মানে অ্যাডমিনিস্ট্রেটর দিয়ে
এই জায়গাটা তো ফিলাপই করবে। আমাদের অপোজিশন থাকে।
এই যে ওকে
Yes, so the division may pass an order directing that you go to controlling authority.
My lord, apart from that, his grievance is three
I have
types
not
of
seen,
grievance.
I have not
One
seen
is,
that.
my lord, regarding 20 lakhs gratuity, as per the
I have not
notification.
seen that.
My lord, second thing is, my lord, interest on gratuity. I have
My
seen
lord,
because law says section 7
One, one,
There are, my lord, leave encashment. Leave encashment he has paid. The fact remains, leave exemption 300 days. Well, according to Cooperative Society Act, clearly has been provided that not exceeding 300 days. Shall not
তাহলে
exceed.
দিন তো ইয়ে।
Now, question is, he has not paid for the leave exemption, although he has been made in the district. My lord,
Okay, since state wants and since there is a provision, I am relegating the matter, giving liberty them to application to the controlling
my lord.
authorities. Huh?
Yes.
Controlling authority
Yes, my
will
lord.
decide.
Yes. No,
my lord, kindly hear.
Division bench order, that is binding upon me.
No, no, kindly hear me, then your lordship pass.
Yes, yes, yes. No, but-
Kindly hear me, then your lordship pass.
yeah.
I have not seen the judgment. Copy has not been served upon me. I cannot accept. I will have
not a
to,
copy, sir.
I have to. My lord, this is difficult. If he wants to, now,
Just
now, my lord, kindly consider. Who he is appearing for whom?
now,
First.
now question can arise.
Please.
Nothing but
Mr.
Please,
Bhattacharya,
I will make
division
my
bench has been division bench.
No, 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 no. Question of locus.
Yeah,
He, no, no.
come to page.
No, no, no. You
four.
also kindly come.
We are concerned that after we therefore hold the writ petition shall be at liberty to apply before the controlling authority.
No, no,
Appraise
first of all, you will also
if
kindly.
such application received,
No.
proceed treatment in accordance with law.
You will also kindly hear me first, then you will also. My lord, he is appearing for whom? He is appearing for whom? There is no board of directors. He cannot appear for the board of directors. Respond number 5.
now the matter
Please,
is going on against.
please,
him.
please,
Far he is
please.
against that,
If
not
he has,
taking the plea.
this is, if he has no locus to appear before your lordship, how your lordship can create the locus?
That is a technical issue. Actually, the issue
No, no, no.
issue
Kindly
has been
respond
resolved
number 10.
by a
Respond.
division bench of this court. That
No, that
judgment
is separate aspect
binding.
of the matter.
Their judgment is
I will
binding
meet the
upon
point.
me.
Sir,
No,
I will give the
as-
other judgment. Kindly see, respond number 4 and 5 he is appearing. He cannot appear. There is no board of directors. How he can make submission?
Okay, it is the state also making such submission.
So then
That-
his appearance be excluded. Then I will meet with the state. Let his appearance be expunged.
But he has
Because
taken
you
one
will also can see in the letter.
He has taken.
In the letter, you
But
also
this
can
is the, my
see.
lord, this is the.
It
It's a
is here for-
technical issue. Actually, you want money, the rest 10 lakh.
No, in the
Question
letter.
is whether you will get the rest 10 lakh or not.
I will.
Without wasting the time here, you approach the controlling authority, let the controlling authority take decision, and thereafter avenue is open to you either to come before this court or to take
And
appropriate
fix up the date.
steps.
Fix up the date. Right.
So that would be better. That would
No,
be
this is the division
without
bench judgment.
raising. You come to page 4.
Page
That
4.
page 4. We are therefore hold third paragraph from the middle portion. We are
No.
therefore hold that the
No,
petitioner shall
no.
be at liberty.
We are conscious that controlling authority had once decided the claim of the writ petitioner.
Yes.
First of all, he approached the controlling authority. Thereafter, he does not survive. We therefore hold that writ
That
petitioner
means that
will apply before the controlling authority.
uh,
This is in connection with the same. He did not come before this honorable high court.
when the legislature
No, you facts, you logically consider facts have to be considered. Judgment does not rely upon without facts. You cannot lordship rely any judgment without any nexus to the facts. Now there was a proceeding under the payment of gratuity under the controlling authority. The division bench said, you are liberty apply before the afresh before the controlling authority. Then how you also can create the authority? The lease emanates from controlling authority. This is not the issue now before your lordship. I have come before this honorable court for getting my retirement benefits under the law, statutory violation. Kindly see law. Kindly see the law, 106. Kindly see rules I am giving both of them. Kindly see. Facts must tell you the fact of the law. Because the facts are completely different.
ও তো জানে
Kindly see. Kindly see my lord rules.
Rule
Rules.
106.
Rules 19. Rule 106. Cross 19.
19 2 and 3.
আরে আমরা বলছি তো
কি বলছে?
1920 উনি দিন দেবেন আমরা বলবো করে দাও
Yes.
Kindly see retirement and retirement benefits. My lord got the statutory
yes.
rules. My
Yes,
lord,
yes.
these particular statutory rules are not the statutory rules. These are the legislative rules under section 157. 4.
Yes, yes, yes.
Every employee of a cooperative society shall, he retire on superannuation, attaining the age of employees of cooperative shall be eligible to payment of gratuity as per provisions of Payment of Gratuity Act 1972. How they can say I will pay you 10 lakhs. But Payment of Gratuity Act said it is 20 lakhs. So how the rich code will go there not to do justice, and injustice will continue, and how he can curtail my entitlement under the law which has been given to me. I am getting the benefit under the law. This is kindly see section 157. This is not the statutory rules. Section 157(1) kindly comes to section 157(4). All rules made under this act shall be laid before the state legislature as soon as they are made, and shall be subject to the modification, if any, whether by
Section.
repeal or amendment as the state
Section.
legislature may make. So it is legislative rules. You lordship cannot add something which is legislature has said. High Court or Supreme Court has no right to add anything or modify the law. Law says I am entitled to gratuity under the provisions of Payment of Gratuity Act. Now 18 circular law has been amended, and government said government of India said it will be, central government said it will be 20 lakhs. How then curtailment amount? Now they have understood the same, and they have introduced 20 lakhs. Why retrospective
Yes, yes.
effect will not be given? Why from 2018, from 2018 the effect will not be given? They are above the law. Law says I am entitled to gratuity under the Payment of Gratuity Act. Provisions are there in my favor. And these facts, we can't see the judgment, the division bench judgment, can't see what are the facts. I am reading. Intercourt appeal in the answers to writ petition is argued the judgment that is learner decline to raise a dispute with regard to non-payment of gratuity leave salary before the register of cooperative society, West Bengal, in accordance with law, such and such. If petitioner retire from service, such and such, holding the state loan, such and such, by order dated, the learned judge dispose of the writ petition with the direction that without prejudice that concern has writ petitioner to approach a competent authority under the provisions of Payment of Gratuity Act of the calculation. In compliance with the same, we are informed by Mr. Lana Sajan, Chief of the Harbour employer. Now kindly comes to page 4. 4 says we are conscious the controlling authority was decided the claim of the writ petitioner, but in view of the coordinate bench dated and such judgment does not survive, we therefore hold the writ petitioner shall be at liberty to apply before the controlling authority afresh. If such application is received, controlling authority shall, because the matter was pending before the controlling authority. How this ratio can be applied in this particular case? Because High Court said you have to be given all admitted retirement benefits. That includes 20 lakhs under the Payment of Gratuity Act. That order was not appealed against. He released gratuity. How can turn back that I will not comply with the law?
এটা দেখান এটা দেখান
Now they have realized that it will be 20 lakhs.
Yes, yes, yes.
These are my submissions.
Don't worry, yes. That's all?
Already, ঠিক আছে।
Yes.
আরে ঠিক আছে, ভালো already returned the
And yes,
This is my application.
DVC has come against Pollution Control Board.
Restoration application. This is there.
Who is your other side?
And not all the respondents. Everyone, sir. This is I'm appealing on behalf of the Damodar Valley Corporation. But it's kind of considered the order. Why I am recalling on page 90. That is what that is what they know.
Only
That I have challenged the notification. I have served both the respondents through mail.
delay of how many days? Delay of 589 days.
I have stated.
Whether state is the authority, state is the respondent, or only Pollution Control Board.
I have served.
So how,
COVID period, but that time and
why you have made them party as personal name by name? Why you have made party?
I have
Sri A.K. Bosu, Secretary Sachansa, Sri Sachansa, Chairman, Sri Sachansa, why name?
respondent is there. All the respondents.
Why name?
Hmm?
Whether they have got any personal liability, they have mentioned their name.
Criminal case was lodged by before the Asansol court. That is why when I state the order, Lordship kindly the order, by the interim order, page 19. 21. But page 19, all the orders state by the my lord.
No, you change they change them as a party. They are not personally liable. All secretary such and such, they are not personally liable.
No, they have.
Why you have made them here? Come here, don't defend it. Your junior most probably is J.C. Jetli, Chairman Damodar Valley Corporation.
Yes.
Why you have made them here party?
Criminal complaint was lost.
Huh?
Criminal complaint was lost because
As personal.
Yes.
Mr. Ta, you are saying.
Lordship
He acted as a secretary or chairman. That means that his chair has lost the complaint, not that particular person.
Lordship kindly consider the cost.
He, by filing any criminal case, whether he was seeking redressal of his personal injury. If your junior tomorrow assault me, that would be personal. I am going to market. Your junior find me alone. He is a strong person. I am weak. He assaulted me. It is a personal injury. But if any chair, say the secretary of that or chairman or director, then how you can make them personal party?
Lordship kindly consider my petition. Lordship, I am satisfied your lordship. Why they have in a party to the proceeding? Lordship kindly consider.
Here also you have made chief engineer such and such, A.K. Bosu
Yes,
such
they
and
are
such.
at a party. That is why.
In criminal case.
Criminal complaint proceeding.
So how many days?
1.
Delay. 89 days delay.
At the time of COVID, at that point of time, I am not calm.
When it was dismissed?
Dismissed, Lordship order. Page 21, 20. January 20.
January 20.
Yes, page 21.
So that thing is not available to you.
Other pensioner I have tried, but it was not appearing.
15th March 2022, 28 February 2022.
Yes.
And Honorable Supreme Court thereafter and numbers of judgment stated that whose period of limitation
That-
expired
that
during
stated.
that period.
I have stated,
In between this time, they will get that.
I have stated in my application.
In March 20.
The merit is very serious matter. They have, I have challenged the petitions that how we are using the water, whether Damodar River Corporation is using the water for the purpose of electricity consumption, and made a complaint that you are using and pollution was made. That notification was challenged by the petition. Lordship kindly consider the petition.
Okay, they received.
Yes.
Okay.
Receive করেছে তো? Receive. They have
Union of India member secretary.
even if both the respondent. Both the respondent. Lordship recall the order and fix the date and dispose of the petition.
Law officer, pollution, yes, senior law officer, environment engineer. You have not served upon all.
All
One-
this.
1 and 3.
One and three.
Member secretary and Union of India.
Yes.
And the law officer,
Appear. They have not appeared earlier.
they have not appeared.
Not appear. Union of India, through Union of India, appear and serve my junior, serve the Union of India, the police, both the respondent.
Law officer and senior law officer and environment engineer, Durgapur Regional Office. You have not served upon them. Respondent number 2, 4, and 5.
Keeping it.
You have served only in Union of India and member secretary of the Pollution Control Board.
The pollution control board, main, they are the main Union of India through.
2, 4, 5.
Yes.
You have not served.
একটা দিয়ে দিলে এই সব আচ্ছা তোমাদের এক
Yes, check it.
I have said I have a problem. I have a problem. I have served, no, they appear in the matter.
Union of India and member secretary only.
My lordship kindly page 4. Union of India. Union of India.
But law officer,
One
senior law officer, one engineer.
one person appear on behalf of the Union of India, the other respondent. I have served. Kindly recall the order and fix the matter and dispose of the deed.
They will come and says we have not served. Environment engineer, Durgapur Regional Office.
Union of India, same person. Lordship knows Union of India. I have served the central government advocate. Central government advocate.
You serve them, I am keeping it in the next week.
They are not appear. Not appear. Union, I have served main respondent in Union of India and the pollution control board. They have no objection.
I know they will not appear, but you, since you have made party and it is dismissed for default, they may have a right to oppose.
Communicated the order, Lordship's order.
Yes.
I will communicate the Lordship's kindly recall. I will communicate and restore and fix the matter. Kindly dispose of it. The very
It shall be disposed of. You just serve a copy of this application and then come.
next day.
I am just order. When you say when it will be said, today is 24, you say on which date it will be.
He has a-
Next week,
next
3rd April, come on 3rd April. You just serve.
kindly give direction.
Huh?
We have the plain copy of the order. election should be recorded in our process time.
Any order is required?
Yes.
Mr. Dal.
My lord, in this matter, I beg to appear on behalf of the petitioner. Lordship, last occasion on 17th of this month, your lordship was pleased to restore and to consider my delay application, condemnation of delay to the same. And there was a direction, my lord, for communicating the said order, which is already being complied, but due to the short time, the applicant is not available. Today,
Okay.
no, today I am not going on merit. Lordship, on 20th, I received a mail from the petitioner. I need to file a supplementary affidavit. Lordship, kindly give such liberty to me as to why in the year 2012, a supplementary affidavit was prepared by the erstwhile lawyer, but unfortunately, that was not filed. As there are the dispute for the provident fund of the casual laborers and their number, whether that is 129 or 64. It is the question. It should be specified.
Okay. Yes. I mean, Mr. Dr. Lanet advocate pending the petitioner submits that the service in terms of the order dated 17 March 2025 is yet to be effected. Stop. He further submits that he prays for leave to bring certain documents and subsequent.
My application.
My lord,
Your lordship.
my lord,
6 applications.
in this matter, Shanajit Kumar Ghosh, he is engaged in another court.
Certain application. Let the application be disposed of. What is the application?
My lord, on
I
the
have found
last,
6 applications.
kindly remember, my lord, on the last occasion, my lord was pleased to direct, my lord, my advocate to record, my lord, to give a compilation of, my lord, all these applications. What are these applications about? My lord, if I may tell your lordship, there are, my lord, can 3. Now these applications which are pending before your lordships are can number 3, my lord, 5, 6, 7, 8, and 9.
So every application can be heard out along with the main lead petition.
Lord, I would respectfully submit and request your lordship, Lord, kindly take up can 3 first, because all other events, my lord, which are covered by the subsequent applications, my lord, namely, my lord, can number 5, 6, 7, 8, and 9, are all dependent upon can 3. If today, my lord, after hearing can 3, your lordship is pleased to allow can 3 and modify the erstwhile order passed by Manager Justice
That
Dotto.
cannot be done without hearing your other side.
Yes, my lord.
Without hearing. And
Yes, my lord.
I find only can 9 was filed
Yes,
for
because-
extension of interim order.
yes, because this is really now,
What was the interim order?
but the interim order was a stay of an eviction notice.
Stay of
Now,
eviction.
my lord, these
Whether
petitioners are
interim
already
order-
evicted.
This interim order was passed for a limited period or till the disposal?
Initially, a limited period, not extended,
Up
and
to-
thereafter not extended.
Not extended.
No.
So actually there is no interim order now.
Yes, as of today.
Uh,
That's the reason, my lord, what I was respectfully
so
submitting.
SAP is infectious. 7
Yes.
is infectious.
Like literally so. Literally so. I must tell you, lordship, literally
Yes.
so. Because,
So
because
except 7,
my lord,
all our application
Yes.
would be heard along with the writ
no,
petition.
my lord, I would respectfully, yes. But the writ petition, this is a subsequent event, my lord, which has happened. My lord, the writ petition, these petitioners, possibly your lordship has heard this matter on a number of occasions, on earlier occasions, I am told. My lord, this, kindly remember, these petitioners are shop owners and were licensee and lessee rather under the Metro Railway in respect of their shops which are allotted to them in Taliganj Metro Railway Station. Now, my lord, there are certain disputes which cropped up by and between, my lord, the petitioners and, my lord, the Metro Railway with regard to the extension of the lease, etc. Now, this writ petition was filed. This was heard by my lord Justice Dotto, Dipango Dotto as the lordship then was, my lord. And an interim order was passed by his lordship on the on consideration of that Metro Railway will calculate what is the actual amount of occupation charges which are due from my clients, my lord, based upon, my lord, there's a typographical error which crept in. Instead of square meter, it went as square feet of the shop room. Let's say I have a shop room, my lord, measuring, let's say 20 square meter. And, my lord, it went as square feet. But then his lordship also directed, I'll be placing that order before his lordship, which says that as agreed upon by the parties. So now, my lord, this order was passed long back when Justice Dotto was taking up, 2007. So thereafter, my lord, even Metro Railway also did not demand, my lord, any amount from us based upon square feet. They demanded upon square meter, all are paid. Matter took a turn in 2021. The petition was pending. Suddenly, my lord, they raised a demand wherein they said that you have to pay on the basis of square feet. So, which was around 2 or 3 lakhs, a couple of lakhs was the demand which we have paid. Suddenly cropped up to, my lord, crores, 7 crores. And today the demand is more than 100 crores based upon square feet. It was nobody's case that our the lease which was a license which was given to us on the basis of square meter. Metro Rail could not, in their affidavit, could not show even a single document that it was on square feet. So therefore, we filed this
Now,
application.
whether there was any written instrument
No,
by
nothing.
virtue of which you are inducted
I am entitled to pay.
inducted in the shop room.
Yes. And
Whether
based upon square meter.
any written
Yes.
instrument,
Yes. And square meter. I shall show
their
those
square
square
meter.
meter. All, even Metro Railway, they are learned senior standing counsel of the practicing in the High Court. But we have annexed that letter also. He communicated to the Metro Railway after that order was passed that based upon square meter, you have to demand.
So when you inducted first, thereafter you made payment, you have the document to show that you have made payment.
Yes. Even after
as
that,
per the square meter,
even
and they went on accepting the same
yes. Even
without any demur, without
even
any,
my lord, even after that order passed by my lord Justice Dotto.
he is appealing.
Yes.
Oh.
Yes. So even after that also. So, my lord, we have those documents, we have annexed that. So that's the reason I was respectfully requesting your lordship. So this CAN 3 is very important because this amounts to a modification. If CAN 3 is ultimately held in our favor, my lord, all these subsequent applications will go because these were dependent upon CAN 3. So therefore, my lord, I was respectfully requesting your lordship, my lord, kindly take up CAN 3 first and kindly disclose CAN 3. This can take care of all the applications.
Now, whether the writ petition has been disposed of
Writ petition is pending. Writ petition is pending
by an
In-
interim order, Justice Dotto
because
was passed.
this is a subsequent yes.
Passed that order.
Yes, because the writ petition was moved as by an interim measure, my lord, this order was passed in the writ petition. Writ petition is
The
pending.
court ready to hear the main matter. Why are you seeking modification of the interim order?
Because, my
The
lord,
interim order was passed on
no, 2007.
8 June
Yes,
2007.
because, my lord,
Whether it is
My lord, after eviction, they have
Because-
already been evicted.
my lord, today,
Thereafter, contempt application
may I,
that was also dismissed.
my lord, I hope,
On a contested on contested hearing, that contempt was dismissed.
my lord, may I have, I
And
have,
now
I hope
that
I have a
this-
right of audience first. My lord, I will not shout. My learned friend may have a good voice, my lord.
so one by one. So can now has become impactual.
Subsequent,
Making
the-
this
uh,
observation,
regarding,
can 9 be disposed of?
but can 9 can be disposed of, but can,
Acha.
My lord, I am just
Yeah, based on the submission made on behalf of the এই একটু এদিকে আসবেন আপনাকে আসতে এইসব রিপ্লাই ফিপ্লাই রিট পিটিশনের কিনা দেখুন তো আমাকে শুধু রিট পিটিশনটা দিয়ে দিন ইয়েস এগুলো কেটে কেটে দেবে
lordship has got that copy of the writ petition and affidavit.
রিট পিটিশন ওকে আই এম ট্রাইং টু ফাইন্ড আউট দ্য ইয়োর পেয়ার ফার্স্ট what was your peer you filed this writ petition challenging one memo dated 4th May 2007. It is here. Where is the 4th May 2007? Page
198.
198. 198, your letter. Your letter to the
No.
estate officer.
No. My lord, this is 198, my lord, we will get that. This is annexure P17, I
Yes,
find.
205 most probably.
My lord, this is kindly see, my lord, 4/5/2007.
4/5/2000 years in pursuance.
My lord,
of the
in persons of
notice
letter
dated
dated
under
18 1. This is the Metro
section-
Railways. Lordship.
So public premises eviction
Lordship.
of unauthorized act 1971 was invoked against you.
Lordship.
You appear before such and such personal hearing.
My lord, this writ petition was filed, my lord, challenging this order. My lord, issued by my lord.
So you are directed to vacate the premises.
Lordship.
Yes. Thereafter,
So on
have
that-
you
on
preferred
that-
any appeal?
No.
Huh?
No.
There is a appeal is there, statutory appeal.
My lord, in that event, my lord, I am newly engaged in the matter. So, my lord, then I am.
No, statutory appeal.
My lord, I'll satisfy on lordship on that. My lord, kindly then take it up next week. My lord. Let me get ready. Well, I'll just get ready in this preparation because I was told that.
Have you bought the book?
My lord, from 11
5
to
actually 5 relating to the dispute. 7 is eviction. Section 9 there is most probably appeal. Section 9 there is.
my lord, it is under the Railway Act, my lord, not under the public.
You have invoked public
No,
premises
there were
eviction of
Yes, my lord.
unauthorized act,
Appeal provision.
whether railway or not. You have invoked the same this year. So this act make provision for appeal
Yes.
against the order under section 5.
My lord, I'll take instruction with regard to that because I'm not briefed on.
Have you not brought the book?
No, but, unfortunately, I did not bring it today. Brother.
Have you brought the book?
And,
Book, 1971
No,
book.
My lord, I'll kindly take it up next
public
week. Not,
premises unauthorized.
yes.
Section 5 and section 9 of that act, my lord, very vital, my lord.
Oh.
If your lordship kindly takes it up, my lord, on any other day, my lord, I'll come in the book also. I'll come ready on this issue.
এইখানে না বাবু এই কিছু বই টই এনে দেবেন তো বুঝতে পেরেছেন ওখানে যেমন ছিল এর একটা কোথায় গেল
11 পরেই মানে এই সপ্তাহ থাকছে না মানে পয়লা বৈশাখের পরে সপ্তাহ ওই তো 15 অব্দি বন্ধ আছে 15 তারিখ ছুটি আছে
section 9 there is a appeal
lordship
an appeal shall lie under section 5 এবং section 7
yes.
any order which is passed
lord
by
is-
them
my
is
lord is
appealable order.
yes, my lord is absolutely correct, my lord. But why this appeal was not preferred, my lord? I'll kindly give me some time, my lord, to take instructions on that.
The order was passed in 2007,
Lordship, 2006.
18 years ago.
Lordship.
So
Lordship.
you again and again all the subsequent event
Because
you are filing an application
no,
and seeking stay of operation of that sale.
no,
But
my lord,
keeping the main
And my lord-
unless consider ask tell your junior
lordship.
if the said order passed under section 5 or 7 is allowed to be alive to you keep it alive and you challenging the subsequent action
Lordship.
but main order is remain alive
No, my lord, they are here.
whether any officer
Lordship.
will have power or any court shall have power to nullify the subsequent action when the main order is still alive.
Lordship. No,
Main
there,
order passed either
the
under
here,
section
no, here,
5 or 7.
no,
Is that right?
my lord, here the difficulty,
So what they are doing as per that order, all are their subsequent action.
no, my lord, I am told a representation was made, my lord, in the form of appeal. I shall show you, Lordship, my lord, here subsequent some developments have taken place, they have taken certain
Subsequently,
action.
they are saying you vacate.
No,
Subsequently, they are saying you pay your amount
no,
unpaid.
That
this
is the
is,
order of the
no,
honorable
I
court.
shall,
Unpaid amount.
no, no,
you
no,
pay.
I
That
shall
same
show,
point
no,
was
no, no,
raised
no,
by your
not,
lordship.
my lord, not unpaid amount. What has happened, Justice Dotto, my
I
lord,
am just giving
no,
example.
by the interim order,
I am giving example.
I
By an
absolutely-
order,
I shall be
they
placing,
have by passing an order
my
under section 5 or 7, whatever may be,
lordship,
of 1971
my
Act,
lord,
they have directed you vacate.
lordship.
Okay, you have not challenged that order before before the appellate forum.
Man.
Though the legislature has made a specific provision for appeal
Lordship,
in that,
lordship,
you have not availed of that remedy.
lordship.
Now you are going on challenging the subsequent act, which is stem from
No,
the
what
order
has-
passed. in
no, no,
the
no, no. What has happened is that interim order was passed whereby, my lord, the Metro Railway was directed. to-
6 application have filed.
No, kindly see what has happened. Metro Railway, an order was passed by an interim order. Metro Railway was directed, you calculate what is the actual amount due, and we are directed to pay. Now, my lord, they calculated,
7 months.
they let us, they informed us, we paid.
Issue is not that at this stage.
My lord,
Now issue is you are unauthorized occupant, it has been declared.
no, not declared, now dispossessed. We have been evicted. Pendency of the,
Evicted,
yes,
you are
yes,
evicted.
yes, yes, pendency of this
So
petition.
you prefer appeal, what you will?
No, no, no. The question is that pending,
recorded.
no, no, no.
All have been
Pending interim order of this court, when there is an express direction of the court, there was a typographical error which escaped the notice of both sides.
You are focusing on another side.
No, because
Now you are evicted, you have been declared as unauthorized occupant.
no, 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 not declared. My lord.
Direction has been given upon you to vacate.
No, 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 no.
Now
But-
again you see that it would not be square meter, it would be square, it would not
no,
be
no,
square feet.
no, my lord,
do not-
kindly,
That stage
no, no,
is
no.
not there.
No, no, the stage is there, my lord. Why I say so, my lord? I shall be placing those the interim order and the subsequent event. That's the reason I placed with your lordship that can 3. Everything takes care of can 3. The subsequent events are concerned.
Actually, you seeking modification of an interim order passed in 2007.
No, because taking the advantage of the interim order, they have dispossessed my client. This they could not have done. Today, question is that if you're even today, if my lord relegates me to the appeal, let's say I go to the appeal, the appeal will become infructuous by reason of the fact that I have been physically dispossessed.
You have been,
I've been physically dispossessed.
so what?
No, because of by reason of an interim order, because the interim order is by mistake. That's my
There
submission.
Always provision of restitution.
Restitution is always there.
If
No, unless
if anyone is found to have been illegally dispossessed, court by authority has power to
No.
direct his
exactly.
restitution
No,
of proceeding.
no, absolutely. No.
144 of the Code of
My lord, I
Civil
bow down.
Procedure.
I bow down. But
If anyone is
no.
dismissed illegally, reinstated.
No. I bow down to that, my lord. But the difficulty today will be, my lord, this.
Otherwise, there shall be no remedy.
No. Because this interim order, my lord, passed by this honorable court has to be, my lord, clarified by your lordship. Because the appellate authority, my lord, or any subsequent judicial, my lord, authority will not have a power to, my lord, undone this particular interim order where there is a mistake. When I prayed for a modification of that order, because they have taken advantage of an error in, I would respectfully submit, a mistake in an interim order and dispossessed me. So that chapter has to be undone by your lordship, and thereafter, my lord, relegates me, I'll go. Today, the difficulty is, my lord, kindly appreciate the appellate authority, even if my lord delegates and I go there, we'll have no power to restitute.
The blood has become polluted.
Lordship.
And for this court, various sorts of wounds are coming out.
Lordship.
Lordship. You are giving to ointment to the wounds without making any treatment of the polluted blood. Blood has blood polluted.
Kindly consider one sufficient.
No.
Whether at this stage,
difficulty, my lord,
court can restore their position.
My lord, the difficulty
At
is
this stage.
only thing. No, because
Then
pending.
what is the remedy? If no, Then my lord, what is the remedy?
You prefer appeal,
no.
but you will satisfy the court regarding the condonation of delay. You just prefer appeal
No, no,
under
then
section
unless,
9.
my lord, if I, my lord, today, my lord,
Under section
lordship,
9, no?
lordship, my lord, today, my lord, if my lord relegates me to an appeal, if I go there, or I'll satisfy that part, that chapter is all right. I'll submit on that. But there's a separate chapter, my lord, when taking advantage of a, in my respectful submission, a mistake or error, my lord, in the order, typographical mistake, they have physically disposed me. They kindly appreciate that particular clarification cannot be done by the appellate authority or by any other judicial authority, because this has been passed in this state petition by this honorable court, that order. So that clarification at least, my lord, will be necessary for my lord. So far as this particular
No,
error,
it is required. You have already
no, because the
disposed,
no, railway will take a submission.
already evicted.
No, because on the basis of, well, demand. Why? Because, my lord, they said, the order says, actually, it is the parties, I'll be placing that order before my lord, that it is per square, on the basis of per square meter. So per square meter, pursuant to that order, they made a demand, we paid.
Whether such thing has still relevant.
Yes, because the pending,
You are not in a position.
no, pendency of this.
You are not in a occupation, not in occupation of the sub room allotted to you.
Because these
You
are
have
subsequent,
been
it's
on
like,
the premises
no,
allotted to
but
you.
my lord, it's like lease pendants. If I may respectfully submit that pending interim order, pending writ petition, suddenly you raise a demand from 2007, the demand was made in 2021. I could have understood after this order, they straight away made a demand that you pay on the basis of square feet. They did not. They, on the contrary, they raise a demand on square meter. I paid. Suddenly 2021.
Okay, I have understood.
Kindly fix the date, my lord.
No date. You make submission on merit of the writ petition. So you have challenged the order dated.
My lord, so far as writ petition, my lord, kindly give me, kindly accommodate me, my lord.
Why? You have
Because, my
done-
lord, actually, I went candid before a lordship, lord, I came ready with can 3. But I am a new inductee in this matter, my lord. I was not there all through this
You have
series.
challenged the order
Lord,
4th May 2027.
Lordship.
And so it is apparent that the said order was passed under section 5,
Yes.
1 of the public premises
Lordship.
eviction of
Lordship.
occupant act 1970.
Lordship.
So section 9 provides
My lord,
an appeal,
this chapter,
provision for appeal.
this chapter,
You, without preferring that appeal, you have challenged that.
my lord, yes. So far as that
So
is concerned,
statute has made
my
this
lord, I
alternative.
shall satisfy that one. Then, so far as that is concerned, my lord, kindly give me an opportunity to come back, my lord. Because I have been inducted, I was briefed clearly on can 3, my lord. To be very honest with your lordship, I was not there all through this, my lord, I have possibly seen, my lord. I have a new inductee, my lord. I have to, my lord, I have been briefed this writ petition also.
Kindly consider that after 12 years, a degree cannot be also executable.
No, why not? When the proceeding is pending, it is not a disposed of matter I have come.
After 17 years, they have come with the modification of
Yes.
the typographical mistake.
Because your demand was in 2021. You did not raise your demand. 2007 order, a demand made in 2021. Don't say that. You have, my lord, you have taken advantage of a wrong.
Yes.
My lord, kindly hard
So,
it.
hard the
Kindly keeps it hard in part, my lord.
appeal for the representative. Yes.
I appear on behalf of the state respondents. In nutshell, my lord, matter relates to higher scale of pay.
Your Lordship,
That
this-
is,
Your Lordship, before submissions are made, there is a restoration application along with a condonation of delay.
that was allowed.
Allowed.
On last occasion, that was allowed.
Lordship, I was not appearing, Your Lordship. In the event, it has been allowed, Your Lordship. This is a 2008 matter, Your Lordship. The present situation and the instructions need to be obtained from the department, Your Lordship.
I am trying
regard to
to
this matter.
I am trying to clarify on that issue, my lord. I am trying to clarify. Matter relates to my lord higher scale of pay, that is MSK. Before entering as an assistant teacher in the respective schools, I completed on two graduation degree. One is BA honors in Bengali, another is physical education and work education. I appointed under the category of physical education and work education. Thereafter, I enhanced my qualification from BA honors Bengali.
When?
After joining in the.
In which year?
I'm coming. I am trying to place the nutshell at first point. Thereafter, I enhanced my qualification from BA Bengali honors to MA.
Yeah.
I applied as per the government order itself for higher scale of skill. On that point, in the particular issue, there is no specific direction of the government. Thereafter, specific direction has come. If there is any shortage of teacher, then the teacher of another faculty can get the higher scale of pay if they, with one condition, if they take at least 5 classes in a week. Now, after filing this writ petition, ওইগুলোতে যেগুলো টাইপ করেছিস my lord, the writ petition was taken up by this honorable court, another coordinate bench, and perhaps it is perhaps in your lordship file that there was a direction, interlocutory direction. Since this is a change brief, my lord, I cannot sure, but so for the communication concern, I can say before your lordship that as per the direction of this honorable court by an interlocutory order, the authority was directed to consider the issue. I am placing that order. That later.
This is an order seeming to be additional district inspector of school. But this I have received this
I have
brief,
placed
knowledge of this document.
I have placed with your lordship.
Even if there is a document, I have to take instructions on that.
District inspector of school addressed to headmaster Bakra High School. I don't have any right to stop it. Hearing as per order dated eligible of the Honorable High Court, Kolkata, passed by the Honorable Justice such and such. My lord, kindly see the WP number. WP number 31145 of 2008. That is the present writ petition. So one hearing was conducted as per the direction of this honorable court on 12th February 2009. I don't know what was the fate there. So far, I have been instructed by my client that on that date he appeared before the interview board, rather hearing. But thereafter, no final result has come. I am handing over one.
No such direction is given by this court, at least.
Kindly see
At
the letter.
least no
Reference and
no interlocutory order was passed by directing the to consider. I don't know who make this communication is required.
That is communication from
Whether
the
it was miscommunication.
to headmaster.
If direction is given to the authority to consider, that means he is getting final relief.
My lord.
How as interlocutory relief that can be given?
Your Lordship, I have no knowledge of
if the court decides the issue is should be relegated to the authority to take decision.
My lord,
Court will not encroach upon their area.
My lord, absolutely
So
right, my lord.
It is miscompare. However, forget about.
My lord.
So hearing was taken place by the additional. Hearing was held by the additional district inspector of.
Your Lordship, that is what my learned friend is submitting.
saying.
We have knowledge, or there is no document in
Yes,
support
they
of
have
the
submitted one document.
Your
Now
Lordship,
what
this is a-
happened?
My lord, I am trying to satisfy.
Thereafter, nothing has been made.
My lord, whether now my lord can decide.
Okay, you take instruction on the basis of which communication this hearing was held.
My lord,
A
kindly.
court order passed in such and such in the matter.
Your Lordship, here it says
Uh,
hearing
as
as
a-
per
as a
order
dated.
dated illegible.
So what is a dated illegible? Have you handed over a copy?
Yes,
Yes,
Your Lordship, I just
So
received.
you find
I shall
which
present.
order was communicated by whom?
Absolutely.
But alternatively, my lord can decide the issue here and now because my lord, I am
No. I shall see whether any wrong communication was done
Absolutely.
on behalf of the client, your
Client.
client or not.
my lord, my lord,
Eh?
my lord.
Because no order is appearing as you saying
Yes.
as per your submission that by virtue of an interlocutory order.
My lord.
But you both of you can check that I have not find any such interlocutory order.
I cannot, my lord,
If-
because
If any such miscommunication is made, you also will remain with me that such things should be dealt with
since I have got
with heavy hand.
since I have got this letter.
You both
From
of
the-
you are invited to inspect the record.
My lord.
Whether any interim order
Interlocutory order
is
was there.
appearing,
After
is
getting-
appearing on the record. The other thing.
After getting this letter, my lord, it was it came into my mind.
No.
Perhaps there was an interim order because it's a change brief. So I don't know what happened in the year of 2008. So that was in my mind that perhaps there was an interlocutory order.
Your Lordship, even then, thereafter, Your Lordship, the matter was taken up umpteen number of times in 2018, 19.
That thing has not been stated.
2009 affidavit in opposition, reply. Let this matter appear.
এটা তো কোনো পত্র ছোট বিষয়
That's a Chottawadar order.
Okay, that's
Your Lordship, there is no order.
You. Siddiqui.
And even the press copy has also been served. And he told said he will appear if my lord can tomorrow, I can stay back. And one more.
Tomorrow it would be convenient for Mr. Siddiqui to appear.
Even my learned friend conveyed me, he is ready even to appear if matter is told up.
Okay. So I am, as per your oral submission, I am directing upgradation of these two matter, 31 and 36.
Yes, 36, my lord.
36 upgraded. You do one thing. You give this notice and say that I am coming from Delhi. I think on hearing this, Mr. Siddiqui will come and fixing it tomorrow. Tomorrow it will be upgraded in such a place. Fairly at the top, it would be taken up for hearing
Yes,
tomorrow.
my lord, 36 item as such, 36 item was already disposed of in way back in 2020 in place of that.
Okay, at the time when the matter will be taken up for hearing, you bring this fact to the notice of the court, and court will pass order accordingly. Don't worry. You just ensure presence of Mr. Siddiqui tomorrow. To avoid your further harassment. Okay.
My lord, one thing may I request, my lord? My lord, if my lord, after recess, court will not be taking up further matter.
I don't know what resolution you have adopted.
145 farewell by from the bar association on the 9th floor. Then after 3:30. But what I'm, my lord, what I'm beseeching your lordship.
So I have fixed to matter for delivery of that.
Oh.
I may be asked for.
Oh, it has been disposed of by any coordinate bench.
Yes, because of the other matters.
No, you can refer this matter at the time of hearing.
Yes, but
why you are asking?
Other matters could be heard in place of that matter, because the both petitions was filed in 2020 in the during COVID time. The submission was made because that petition was not properly drafted. In place of that, a new petition was drafted. The court passed it on that petition that this petition is disposed of, item 36, and
granting you liberty to file after.
It was already filed, and in that petition, order was passed about the disposal of the item 36.
So you want the court to call for any record?
Yes,
that has been disposed of or still pending?
No, that is pending.
Pending before any other bench? Manama section, it has not been taken up by any.
That file may also be
Number to
for reference of your order. So that order is available with you. You can, certified copy of the order passed in the petition.
Yes, but my lord, because in the order.
I have a call for Kurun. You give the number, they will.
But wherever the matters are ended today, then next day, my lord, from the next matter will be taken up. Kindly such indication may be given. so that we can also, my lord, appear in some matters.
স্বাভাবিক এখান থেকে হবে আর কিছু উপরে কিছু আছে ওই দিন রিটার্নেবল ডেট কিছু আছে
an indication may kindly be given.
কালকে একটা
forward.
Yes, some returnable matter must be there. In every court there, after returnable matter, it would be. Okay,
from the matter.
Don't worry. ওই রিটার্নেবল ম্যাটার গুলো দিয়ে তারপর যে আজকে যেখান থেকে দেখা আপনি রেফারেন্স মেসেজটা আপনি কল ফর করুন, যদি আসে, হ্যাঁ, তারপর তো উনিও থাকবেন, আপনি আপনার সঙ্গে আবার কথা বলে নেবেন, আমাকে দেখিয়ে নেবেন কি ব্যাপারটা। ঠিক আছে? হ্যাঁ, I don't know. Now you have adopted a resolution. What resolution you have adopted, I shall get it now.
Resolution adopted by the
Huh?
bar. Resolution adopted by the bar.
He is
The chair
member
will
of
be-
the bar.
Fair will be given by
Chair
the,
will be given
at 1:45.
at 1:45
Okay.
to the honor of
That
the
will continue at least.
তাহলে আমি দেরি হয়ে যাই, তো দেরি করে দেবো নাকি? হ্যাঁ, ওকে।
Your Lordship, Mr. Ujjal Rai is appearing for the petition.
Lordship, for respondent number 5.
Yes. Consequently, the charge sheet, the report of the inquiry officer or the order of dismissal of service, এটা একটু দেবো তো dismissal from service. Issued against the petitioner set aside, the respondent number 225 are directed to disburse the petitioner retirement benefits, treating him as being in service with continuity of service from the date of his suspension. However, it is clarified that the petitioner shall be entitled to 50% of his back wages from the date of his dismissal until the date of his retirement. ঠিক আছে? এখানে একটা ওয়ার্ড চেঞ্জ। নেক্সট দেখুন। সেম অর্ডার সিমিলার। এইখানটায় লাস্ট কথাটা একটু চেঞ্জ হবে, ডিসমিসাল ডিসমিসাল ফ্রম সার্ভিস অফ ওটা পাঠিয়ে দিন।